Welcome to the Comply and Outperform webinar series, where we explore the challenges, opportunities, and innovations shaping the AML and KYC landscape.
Hello, and welcome to this episode of our webinar series looking at trends and developments in financial crime around the world. I'm Tom Devlin. Pleasure to have you with us. For those of you who've not seen me before, I was one of the co-founders with Stephen Platt of KYC 360 and was a regulatory lawyer before moving over to the technology side of things. And for today's webinar, which is on the subject of UK AML regulations in focus, a very, very popular topic, I can tell you, given the number of people who have indicated they would like to attend. We are delighted to be joined by a practitioner who's on the front line of contemporary trends and developments within the UK in the AML space, Neil Swift. Neil is a partner in the business crime team at Peters & Peters. He's been in practice for around 25 years and has advised corporate and individual clients during that time in fraud, corruption, and money laundering issues. He has also dealt with inquiries by and prosecutions by all major domestic law enforcement organisations and worked closely with lawyers in other jurisdictions where there is overseas law enforcement interest. He additionally has experience in corruption, mutual legal assistance, extradition, tax delinquency, and all forms of financial crime, including that investigated by the FCA. Neil, welcome. It's a great pleasure to have you with us. Really looking forward to today's chat.
Thanks, Tom. Really good to be here. Nice to meet you, everyone.
So there's a lot for us to get through in today's session. It's obviously quite a hot topic area at the moment in the UK. Where I thought we might start, Neil, is on a topic which I know is close to your heart, or certainly your practice, and that is the increasing use of account freezing and forfeiture domestically within the UK. I wonder for our viewers if you could firstly explain what account freezing and forfeiture are, and then what trends we've been seeing in their usage in recent times.
Sure, of course. So account freezing and forfeiture orders were introduced at the same time as unexplained wealth orders, actually, so by the Criminal Finances Act 2017. Unexplained wealth orders were the sort of poster child of this piece of legislation. Massive fanfare. It was the tool that was going to be used to combat mafia. But of course, they've been used relatively infrequently, whereas these orders, much less heralded, have had a far bigger impact and have been used far more frequently in my experience. So in essence, a law enforcement officer goes to a magistrate's court, which is the lowest level of criminal court that we have, and he has to, or she has to provide an information to the court which basically says, I've got a reasonable grounds to suspect that money in this particular account is recoverable property, so broadly the proceeds of crime from anywhere in the world, or it's intended by any person for use in unlawful conduct. And again, broadly speaking, unlawful conduct means crime. So on that first application to a magistrate's court, ex parte, the court can order the account to be frozen for up to 2 years. Now, just pausing there, in my experience, the practice has developed over the time that these orders have been in place. So rather than 2 years, the usual order at the beginning will be 6 months with a 6-month return date if law enforcement are still investigating. Now, at any point during that period that the money is subject to an account freezing order, that law enforcement can do one of two things. If they are satisfied that their suspicion has moved to being satisfied that the money is the proceeds of crime, then they can do one of two things. They can either just simply serve a notice on the account holder and say, unless you challenge this, the money is going to be forfeit. Alternatively, what they often do is that they'll actually list an application for the money to be forfeit. So there'll be another court hearing, and the court will actually have to make an order. Now, these things were introduced really to fill a lacuna. So leaving aside criminal prosecution and confiscation after someone's been convicted of an offence, under the Proceeds of Crime Act, there are a number of different mechanisms by which money, whether it's in an account or whether it's simply in the form of cash or indeed any other property, can be forfeited on the basis that it's the proceeds of crime. Now, the powers that law enforcement had before these orders were introduced were only available for sums over £10,000. And that meant that when law enforcement was receiving suspicious activity reports from banks or whoever for sums of less than £10,000, there wasn't actually anything that they could do about it. So this piece of legislation was introduced, and now it actually has no upper financial limit. So the jurisdiction doesn't end at £10,000. Sums way in excess of £10,000 have been frozen by these orders. In fact, the largest series of these orders that I dealt with, all in relation to one client, was a total of 20 million. And I think that the biggest one that I've heard of was a succession of orders over accounts connected with one particular individual, totaling almost £100 million. So these things have become very, very attractive for law enforcement to use. Instead of going along the other route of civil recovery in the High Court, they don't need to do that. If it's money in an account, they can just go to the Magistrates' Court and get one of these orders, which in essence really means that you, as the person who has a claim over the money, really have to start cooperating with law enforcement, provide your explanation about where the money comes from, because otherwise you're going to be facing a forfeiture application further down the line. And even having provided that explanation, you may still be facing a forfeiture application. So why are these things attractive to law enforcement? Well, in the Magistrates' Court, there are far, far fewer procedural rules than you have in the High Court. And perhaps more importantly, or at least as important, is the cost position. So ordinarily in High Court litigation, if you lose a case, you pay the other side's costs. With these orders, that's not the position. So the starting point is that even if law enforcement obtains one of these orders and is unsuccessful in proceeding from freezing to forfeiture, there's no order for costs against them unless their conduct somehow justifies it because they behaved unreasonably. But that's a very, very, very high hurdle for them. Just thinking about some of the practical difficulties for people who are the subjects of these type of orders, really the courts have very little time to consider the application. It can be dealt with in a matter of minutes. They're often dealt with on paper. Often few, if any, questions are asked of the applicant. There is the person against whom the order has effect. They're not represented. They're not there. They don't know about it. But then they get served with a notice saying that their account has now been frozen. As I alluded to earlier, this often means that you're then facing often multi-million-pound litigation with often very complicated facts involving multiple jurisdictions, which is all being dealt with in a magistrates' court, which spends most of its time dealing with low-level criminal offending that at the moment they can only punish by 6 months. It's about to be extended to 12 months, but that really gives you a flavour for the level of sophistication of the tribunal that deals with these cases. It can be very, very difficult to even get a listing to set aside one of these orders. I dealt with one recently where we got the order on the 22nd of February. We'd submitted our application to set aside the order on the 3rd of March, the Sunday. It was a heavy working weekend. And then I think by the time we actually got a contested hearing, which we needed a day before a district judge, a professional magistrate, we were in towards the end of June, by which time the client's business had been effectively destroyed. because all of its working capital had been tied up. We were successful. We set aside the order, and every single basis upon which law enforcement had applied for the order was effectively dismissed by the district judge. So these are a very useful tool for law enforcement, but if they get it wrong, consequences for innocent account holders can be very, very harsh. And just sort of on that topic, an indirect effect of freezing, particularly since recent legislative changes, which mean that financial institutions can effectively share information with one another where they have concerns about economic crime, mean that every single account held by a financial institution in this country that was either in the name of the director of the company or on which he had signatory rights, or was in the name of a company where he was a director of it, they were all frozen and he was debanked from all of those accounts. So these things are, as Tom alluded to, they're a bit of a bugbear of mine. They are a large part of my practice, and they are, particularly prevalent at the moment. They're attractive to law enforcement because they require relatively little by way of investigation. It's not a full-on criminal investigation, but it has a really, really chilling effect.
You make some fascinating points, Neil, and a couple of things immediately occur to me. One is you alluded to the impact that such orders can have on the subjects thereof, whether the funds are tainted or clean, sort of immaterial if they're frozen for a long period of time, which puts me in mind of the case law around SHAR, which UK practitioners will remember relating to a slightly different regime, but the same principle of what happens if somebody's funds are frozen and they suffer loss as a result, and in particular, who should be liable for that? Is it the financial institution or some other party? So we might perhaps discuss that in a moment. It also occurs to me that there's a sort of third party to all of these, which is the financial institution itself. Many of our audience today will work on the compliance side or perhaps be in a banking environment. And it would be useful to understand a little bit more about what their involvement is or not in the proceedings that you've seen. But perhaps we could start with the subjects of these orders. What are the avenues for challenge that they have? You alluded to them being pretty narrow. What sort of practical prospects of redress have you got if you suddenly find yourself subject to an order such as this?
So there are a few things that you can do. I think probably once your explanation has been tested thoroughly by your lawyers to make sure that it doesn't reveal any unexpected pitfalls, one of the first things that you might want to do is to engage with law enforcement and say, you've got the wrong end of the stick. This derives from my perfectly lawful conduct doing whatever it may be. This transfer was made, for the purpose. Well, it may not even be a transfer, but the money was intended for continued use in my lawful business. Here is a selection of all of the relevant documents which demonstrate the lawful origin of this money. So very often that will be the first thing that the subject of the order will do, because these orders are very difficult to apply to set aside if you haven't made any effort to persuade law enforcement that they've got the wrong end of the stick. Of course, one can just leap straight into that phase and say, I want to apply immediately to discharge the order in whole or in part because I can prove to a court's satisfaction that there is no reasonable basis to suspect that this money is the proceeds of crime. And here is my evidence. And of course, one can do that. There are a couple of reasons why one might not. Obviously, going straight into litigation, especially where you have a costs regime which is going to be very difficult to get over in order to get your costs back, mean that of the two routes, providing an explanation may well be a cheaper route and will undoubtedly be a quicker route to redress if you can actually persuade law enforcement that they've got it wrong. The other route, there is another route, which sort of addresses the fact that it can be very, very difficult to actually find a court hearing, a date for a court hearing within a reasonable length of time, and that would be judicial review, and that is something that I have tried in a case where it's very, very difficult to get a listing in a reasonable length of time that would have allowed the business to flourish. The problem with that is that judicial review is heard in the High Court, in the Administrative Court, and Administrative Court judges are and will, I think, continue to be reluctant to open up an alternative route of appeal, which lots of people might use, which would then clog up the workings of the Administrative Court when there is another route available, a statutory route, to make an application to the Magistrates' Court to set an order aside. So we've tried that. It didn't work. There may be other circumstances where it does work, but really, you have those two options, which are either explain and then litigate if you're unsuccessful, or go straight to litigation.
If we turn the focus now to the financial institutions who may be caught up as a sort of unwilling participant in freezing orders, are they represented at any stage of the court proceedings process? So when an order is made, for example, does it have to nominate specific institutions or accounts where funds are believed to be held, or can it be a general order? And if it's the latter, how are you notified as an FI that you are now, or one of your customers is the subject of an order and you need to take action promptly as a result?
So account freezing orders are very different to what some people may be familiar with restraint orders. So restraint orders are brought where you have a criminal investigation, someone is made subject to a restraint order, which is an order on them. That means that they can't do anything with either all of their assets or the assets that are identified in the order. And what law enforcement commonly does is it identifies the institutions where these assets might be held, and it serves a copy of the order on them. Account freezing orders are different. They are aimed at the money. So it is a specific sum of money in a specific account. And so in order for it to be effective, the order is served both on the institution itself, but also on the individual who it appears has an interest in the account.
So the institution that operates the account would not be represented by definition at the hearing at which the order is granted, but is then served a copy of the order and must, at its peril, presumably, implement the requirements of that order without delay to avoid paying away of funds.
Indeed, and financial institutions are very, in my experience, very well set up systems that as soon as these orders come in, the drawbridge comes down. They're very rarely represented. In fact, I've not seen an institution represented on one of these. They're essentially neutral to the application. They just need to make sure that they comply with it, really.
So if the financial institution complies with the requirements of the order, it's doing its bit and is unlikely to find itself caught up in any question of liability should the order turn out to have been granted on an incorrect basis. Would that be correct?
Yeah. I mean, I suppose I'm sort of leaving aside the question, which I haven't really considered before, whether an institution making a SAR which was fundamentally misconceived might have a problem. I'm not going to deal with that today. But ordinarily, assuming that a SAR was made in good faith and then was acted upon by law enforcement, then I can't see that the financial institution has any liability for that sum of money. I mean, the problem, the thing which I've described as a problem from the perspective of the recipient of these orders, the account holder, is also a problem from the perspective of the institution, of course. So, once it has an order together with the supporting information which says we suspect that XYZ has committed a serious criminal offence of fraud involving whatever the sum may be, then of course that institution is fixed with that knowledge. And so the question will be whether in relation to any other accounts that it operates for the same business, the same individual, or the accounts to which that individual are connected, whether it has a suspicion about those accounts as well. And of course, banks are obliged to take into account whether it has a suspicion about property being the proceeds of crime, because it can commit a separate offence if it then transfers money which it knows or suspects to be the proceeds of crime. So I don't sort of doubt for one moment that financial institutions are in a very difficult position, and of course now with the wider information sharing that's available, that is something that I can see why from the financial institutions' perspective is something that they feel that they can and should do.
In the event that a account freezing order has been incorrectly granted, setting aside for a moment the merits of the order, but let's say there's a procedural error or irregularity in the grant thereof, and the subject of the order suffers loss as a result of funds being frozen for a few months. Is there any recourse for the subject, or is Crown immunity or a similar doctrine in operation so that it's tough luck as far as they're concerned?
So, I mean, there are two potential routes. So, on the costs front, the legal costs that have been incurred by the account holder, then provided that if there's been some unreasonable activity on behalf of the law enforcement agency, then that would give a basis to recover some or all of the account holder's costs. There is a statutory provision for the payment of compensation where an order's been made and then discharged, but that provision is only exercisable in exceptional circumstances. So you're going to ask me what exceptional circumstances are. So far, there is no case law on this, and I rather suspect that law enforcement will be reluctant for there to be very much case law on this. I think that if there is any basis to claim under that provision, it's the sort of thing that is likely to be settled, I think, because they're not going to want an unhelpful decision about what exceptional circumstances might be.
It's fascinating, really, really interesting to hear about that. And in some respects, I suppose, heartening from a countering financial crime perspective that there is a relatively easy to use instrument that allows law enforcement with less difficulty to freeze suspected tainted funds, but obviously with some balancing considerations around the way in which that power is exercised and indeed what that means for financial institutions. If we zoom out for a little bit from UK law enforcement to the wider world, Britain, the UK, naturally being a destination for significant inward investment, both by corporates and by individuals wanting to bring their money here and place it within assets or other opportunities that might exist within the UK. I wonder what you have seen, Neil, in relation to capital controls imposed by other jurisdictions, that being on the exiting of funds from those jurisdictions that might be bound for the UK, and what those could potentially mean for recipient financial institutions within the UK market. And to add for our audience, while we're talking about the UK here, I guess the principles are fairly universal, right? What happens if money is leaving one jurisdiction potentially in contravention of a local law because it exceeds a limit and is being received in your own jurisdiction? Is that something that you've seen or encountered much of?
Yes, it is actually. I mean, I think certainly in most recently, this is something that's really come to the fore in relation to Chinese currency controls. So China, as I'm sure many people are aware, has a very tight regulation over the amounts that people can transfer out of mainland China for personal purposes, and there are similar sort of controls, as I understand it, in relation to commercial transactions as well. As a result of these currency controls, there has, I suppose, developed over a number of years in a very similar way to things like Hawala banking, an informal value transfer system, which many Chinese citizens have used to move money abroad. Certainly there are a huge number of Chinese students in the UK, and often in order to support their students either while studying or as they decide to settle in the UK and buy property, there's been a lot of movement by Chinese families of money from China to the UK. And they found a way of getting around the currency controls, and that is something that law enforcement has relatively recently turned its attention to, because this is a system that can be manipulated and taken advantage of by organised crime. So the way the system works is that you have a Chinese individual, Chinese family, deposits cash with an operator of one of these systems in China. And what the operator will then have a number of different correspondents in different countries, all operating in the same system. But having received cash in China, what it also needs is a source of cash in the jurisdictions to which the people would like to send money. And of course, lots of organised criminal activity generates cash, whether it be drug dealing or people trafficking or alcohol and cigarette smuggling. All of these things generate large amounts of cash. And what those criminals want to do is to put that money into the banking system and then to transfer it wherever they might want it, whether it be Dubai or elsewhere. So we've got this not a bilateral system, but we've got a multilateral system that's grown up wherever there might be sort of large quantities of or a large Chinese population. Now, in many of these cases, what was transferred, the value that was transferred from China, there may be absolutely no question about its legitimacy. It's legitimately earned, and it's intended for legitimate use. It's being sent to support a family member or to allow a family member to buy property. But there are problems that might arise as a result of one of these informal value transfer systems. So, although breach of Chinese currency controls is not a crime in the UK, we don't have currency controls. There's no equivalent type of offending. The problem is that there might have been some sort of misrepresentation along the way. For example, if there's been a payment into a bank about what the money represents, there might be other red flags. There might be multiple sums of cash, each of them below a limit at which a report might be made, all being paid into the recipient in the UK's account from multiple third parties with no obvious connection with one another. So these sorts of red flags are the sorts of things that financial institutions can, and indeed, because this has been a focus for a while, are paying particular attention to. Now, there was a concerted action led by the National Crime Agency against Chinese underground banking, really starting in about 2019. So on one day, they applied, they in conjunction with City of London Police, with regional police forces, with HM Revenue and Customs, they applied for about 90 of these orders in one day. Now, the idea of that was just to sort of send a chilling message to those who operated in this money transfer sector that this was something that they were looking at and that they were cracking down on. It's taken some years, but in fact, very recently there were convictions of I think 7 individuals, leading to prison sentences of almost 25 years for offences that ranged from at the most serious conspiracy to launder money, but also offences of operating unregistered currency exchanges. So this is probably something that law enforcement has focused on for quite a while, and I think that they've certainly done their best to make sure that financial institutions and lawyers and all of those in the regulated sector are aware that this is something that they're cracking down on, and that that gives rise to risk for all of those professionals and institutions, because those warning signs, law enforcement will say, are indicators that this money that's being transferred, although it might have a legitimate source, a legitimate end use, because it's gone through one of these unlicensed money service businesses falls within the definition of the proceeds of crime. And that the wider policy consideration around this is something that, although people may be using with a good faith aim, in fact, it's a system that can and has and will continue to be misused unless they put a stop to it.
It's a fascinating thought, isn't it? And I suppose for some of our audience will take the understanding or application of fin crime controls beyond, as you say, the origin or indeed the destination of funds, and look at the transfer mechanism itself as a possible source of criminality. Neil, when you and I spoke before this webinar, we discussed some other cases that you had seen in this regard, with innocent generation of funds but tainting by way of transmission. I wonder if there's an example that you could share with us to help our audience have an idea of what they should be on the lookout for in order to avoid inadvertently finding themselves caught up in receiving funds which may be the proceeds of crime by reason of the routes that they took to get to the institution concerned. Sure.
I mean, I being very careful about precisely what I say about this, but I did deal with a case which involved an activity that was perfectly lawful. It was a very successful gambler who was so successful that he couldn't actually use any bookmakers in the UK, because the moment that he opened an account and started winning consistently, the accounts were closed. So he, with his business partner, operated a system where they would be gambling on the markets in Southeast Asia. And the problem was that although they weren't committing an offence in doing that, their money, their winnings, were being transferred to them via a series of businesses which were offering money transfer services, but were not licensed to do so. So, in fact, a very, very similar scenario arose in a case which was before the High Court, the Administrative Court, very recently, a case called Freshview Swift Properties, which was, I say very recently, it's about a year ago. In that case, Freshview exchanged 40 million Nigerian naira through an unlicensed MSB for £67,000. Presumably as a result of a suspicious activity report, the police sought an account freezing order over the unlicensed MSB's account, HSBC. The court froze the money. There was no evidence before the court in the application that was made that the payment was unlawful or it came from an illicit source. The company whose money it was contested the forfeiture on the basis that they'd acted in good faith and they'd provided valuable consideration. There was nothing wrong with their 40 million naira, and they intended to use the £67,000 for a lawful purpose. Unfortunately, the court rejected that argument and they forfeited the money. This was the magistrate's court. So Freshview brought judicial review proceedings on two grounds. The first one was a slightly technical argument that it wasn't the whole amount that was obtained by the unlicensed MSB in return for the unlicensed MSB's unlawful conduct. It was only the commission that it earned. So that unfortunately failed. The second argument was that under Article 1, Protocol 1 of the European Convention, its rights to enjoyment of its property, any interference with that right had to be proportionate, and confiscating the whole sum, where the only bit of unlawful activity was the MSB transferring the money and earning a commission, that it would be unlawful, disproportionate and unlawful to confiscate the whole sum. But again, that was unsuccessful. I mean, what I think we can take from this case is that the policy objective in disrupting money laundering in ensuring that people who provide services as MSBs are properly licensed, have proper procedures in place to identify customers, to understand the source of the money that they are transferring. All of that really trumped the recipient's right to their property. And they also found that Freshview actually took the risk here by using an MSB that they knew was unlicensed. So what do we take from this? The focus here is on the money. What is the money? What's happened to the money? Has anything during the course of its passage tainted it so that it's the proceeds of crime? And I think the other point which we take from this, and which will be of interest to financial institutions, is that it sets a really low bar. So if a person suspects that the money was passed through an unlicensed MSB, that makes it the proceeds of crime. And then as a financial institution, you're dealing potentially with the proceeds of crime if you know that it's been transferred to you through an unlicensed MSB. So again, that's some sort of transaction monitoring on receipts of that nature is something that potentially could throw up issues for financial institutions.
MLROs, take note. We have had a change of government in the UK fairly recently. Do you think that the new administration is going to bring any significant alteration to the approach, either in respect of the agencies within the UK charged with fighting financial crime, or in respect of the use of the available tools that those agencies have at their disposal over the next 12 to 24 months?
So I think there's a general direction of travel which the Labour government is continuing the same path that the Conservative government started. So the clear messages, I think, are targeting what they describe as professional enablers, and I think we're also going to continue to see more action for breaches of sanctions. I'm not going to go into sanctions in any great depth, but that's obviously one of the really hot topics when it comes to the interaction between financial institutions and regulation. In terms of tools available, I think one of the things, not just an AML focus, but I think more widely focused on policing organised crime, is whistleblowers. So we have a incredibly modest whistleblower reward programs in this country. So there are very there are very limited powers for the Competition and Markets Authority, and very limited powers for HMRC to pay very small rewards to whistleblowers. I don't think we'll see anything like the sorts of rewards that they offer in the States, where under various bits of legislation, whistleblowers can obtain up to 30% of the penalty ultimately imposed on financial institutions and others for largely criminal breaches. We're not going to see that. It would be a very un-British thing to do. But I think we're going to see two things. I think we're going to see a more formalised structure, and indeed a structure of providing more support and financial support and reward for whistleblowers. And I think the other thing that we're going to see more of is the use by law enforcement agencies of cooperating defendants. So one of the things that is very, very common in US criminal proceedings is that the prosecutors, the investigators, will try and turn the lower level suspects, get them to give evidence against their former co-conspirators. I think we're going to see a lot more of that, because I think it's a really effective way of policing financial crime. If you can get somebody who is inside in return for a reduced sentence, sometimes for immunity, to actually describe what was going on, talk about the roles of all of the different individuals. I think that's something that I think we will see more of. It's certainly something that the director of the SFO would like to do, and I can't I can't imagine that he's saying that without hearing warm noises from Whitehall that might actually get the go-ahead.
It's a fascinating thought. We at KYC 360 recently hosted an event at which the star speaker was a man called Stephen Cohen, who is one of the, I think he would describe himself as the leading lawyer advising would-be US whistleblowers and arranging and bringing their applications before the Department of Justice in the States. Eye-popping sums involved, as you say, Neil, perhaps a slightly alien approach on this side of the pond. But two things that he said were of particular interest to me. The first was that certainly in the US, you can still be rewarded even if you blow the whistle on your own behavior from the cooperating defendant perspective. And in fact, the largest beneficiary so far under the pay-to-say regime in the US, a man who blew the whistle on UBS Bank, received a 9 or possibly 10-figure sum for implicating himself, as well as many others, in tax avoidance over a large number of years by US citizens. The other interesting thing which Stephen Cohen shared with us was that the US wishes to and has taken some steps to attempt to make its whistleblowing program extraterritorial in effect. So he said, if you're the employee of a UK financial institution that has some degree of US nexus and you arrange to blow the whistle to the US authorities, we'll look after you. You know, step this way and we'll make sure that you don't lose out even though you're not an American citizen, which I thought was a very, very interesting insight, knowing from my own days in practice how slender the thread can be to establish US personality. You know, the nearest of things could bring you within reach of that ambit. I also remember from a few years ago now hosting an event with a man called Paul Moore, who some of our audience will recall. Paul sadly since passed away, but he was the HBOS whistleblower back at the time of the global financial crisis, 2007-08. And he quite correctly called risky bets, which HBOS, a large banking group, was making at the time, which turned out to result in its near ruin when the financial crisis broke. And contrasting his treatment and outcome, if you like, as a whistleblower, with that enjoyed by some of those in the US was pretty stark as an exercise. I think he felt with some justification that having blown the whistle and gone public, he'd been ostracized despite having done the right thing, and certainly not being rewarded, although I don't think that was his motivation in the way in which those on the other side of the pond might have been. So it'd be very, very interesting to see whether those moves or directions or signposts that you alluded to in the UK do result in a more transparent culture where firms have to be thinking about, you know, anyone on the strength who could, with the right incentives, go and blow the whistle if they see behaviour that's not acceptable. Neil, we're very nearly up to time, but just as a parting thought from you, we've recently seen the Starling Bank fine, which many of our audience will have read about. A UK challenger bank, one of those that had grown very quickly, fined a very significant sum of money for what were, I think it was fair to say, pretty basic failures in span of control, in particular onboarding tens of thousands of high-risk clients after being told not to by its regulator, and a failure to operate an effective AML screening program over a number of years, resulting in a significant number of customers not being effectively screened over that time period. Do you think, Neil, there's an element of us still, I say of us, of some financial institutions still struggling to get the basics right when it comes to AML compliance?
Yeah, I think that there is, and it's a sort of reasonably common theme through most of the reports on AML compliance in the sector. obviously nobody's going to get it right 100% of the time, but sort of some pretty basic failings have been seen across a number of banks. I mean, obviously, the challenger banks was something that the FCA decided to take a particular look at because they burst onto the scene. They expanded very rapidly. Starling expanded incredibly rapidly, and what didn't happen was that the financial crime controls and checks didn't keep up with the size and the risk profile of the institution. So I think there are lessons for all in the space that you have to look at these warning signs that come. So in some ways it was quite a gentle first step for the FCA to do their Dear CEO letter, to go and look at the banks and sort of have an overall view of what the failings might be, and then coming down very hard when they find an institution that really didn't pay heed to the messages that had been given and continued to make some pretty fundamental failings.
Neil, I'm tremendously grateful to you for taking the time to join us today. It's been a fascinating and illuminating conversation. For those of you who've enjoyed and been interested by what Neil's been discussing, his contact details are up on the screen now. If you would like to get in touch with him, please do so. And meanwhile, it remains only for me once again to thank you, Neil. Great session, really enjoyed it. Thank you very much indeed.
My pleasure.
Thank you for attending today. We look forward to welcoming you on our next Comply and Outperform webinar.